and welcome to For the Record. Tonight we're talking about the new Companies Act, which was recently passed in Parliament. In fact, last week Friday it went through the floor of Parliament and was passed as an act. In studio to talk about the new law is the chair of the committee that handled the submissions on the Companies Bill when it was a bill, Mr. Ashnil Sudhakar. Now you would notice that our usual panelist Joshua Tuere isn't able to make it tonight. He'll be back with us in our next show, but we'll carry on regardless. First of all, Mr. Sudhakar, thank you very much for being here tonight. Obviously, a lot of work went into preparing the bill when it was a bill and then now has become an act. And an integral part was the work of your committee to take submissions and to vet through the submissions as well as the bill itself. Now, for you, after this has now become an act, what would you say is the biggest change we could see so far as the business climate is concerned?
Thank you, Edwin, for this opportunity to explain the Companies Bill to you and to the people of Fiji. You would have seen the number of changes that the committee has done. In fact, the committee sat through for 25 to 30 days straight on this bill, and that includes some late nights too until 1 a.m. On certain days. And what we basically did was we collected submissions from the public, both written and oral, and we scrutinized those submissions to see how they affected the bill and how it affects the economics and the reality of the business in Fiji. As you questioned, what's one major change? The major change here is that there will be categories of companies now. Instead of all companies being classed as one, we have now different categories of 0 to 5 million equal to, that's small, and from 5 million to 20 million or equal to, that's medium, and 20 million over is large companies. The rationale behind having three categories of companies is to, whilst having the companies to disclose their financials, to have them more accountable, the burden on the larger companies are obviously higher than the burden on the smaller companies.
It's interesting that the small business portion goes actually into the millions, the smallest category there is, because until now the small and macro businesses have been classified as those that make anything up to 10, 15, 20,000 a year.
Yes, what we had heard from the submissions was that the current definition of SME, small and micro enterprises, is 0 to 30,000 or 0 to 100,000. That's small and micro. And that was the category that some of the submitters to the committee suggested that we have a category for small or micro as well, from 0 to 30,000. But what must be understood is when you have a bracket of 0 to 5 million, it does cover and does bring into a lot more companies than what 0 to 100,000 would do, or 0 to 30,000 would do. So micro enterprise, say crab seller, might be making 0 to 30,000 or making 30,000. That becomes a small company if that definition was applied. As soon as it made $30,001, it would then go into say medium company, and the obligations would be higher. So what the bill intends to do is have a larger bracket, 0 to 5 million. So all these micro enterprises, small enterprises, those sole traders, those roadside vendors, they're all exempt from the requirements.
So now that we have these categories, the disclosure obligations on the larger companies, you said, is more stringent now.
Yes.
How so?
What actually will happen is after this bill, which has been passed now, it's an act now, and when it's implemented, what will happen is that companies that are small, that is 0 to 5 million or equal to, they are not required to submit their financials. They are not required to submit their financials to the Register of Companies. They'll only be required to submit when there's a request by the registrar or a request by at least 10% of the voting members of that company. Until that happens, they basically don't have to disclose anything. For the medium companies, that is from 5 million to 20 million or equal to, they'll be doing pro forma accounts. Pro forma accounts is just like a one-page or two-page accounts, which gives a brief summary of what the company's income and expenses have been. They don't have to disclose like full financials. For the large companies, for obvious reasons, because a lot more money is at stake, a lot more people must be dealing with them, there is 20 million and over, they on an yearly basis, they submit their full financials, which includes their balance sheet, profit and loss accounts, etc. Those the usual financial documents to show what the company's income and expenditure are and the risks that they carry.
There's a lot of companies in Fiji that fall between the $5 million to $20 million category. Some of them are even publicly listed. The differentiation, if I may seek clarification, isn't that they don't have to submit, they don't have to create their financial accounts on a yearly basis. They would still go through their normal accounting processes.
Yes.
But for the Registrar of Companies' sake,
Yeah.
what's the differentiation between, because if I may explain my question,
Yes.
say for example, let's take FBC as a company. We may fall between the $5 to $20 million category,
Right.
but that doesn't mean we don't carry out our usual accounting practices of writing our financials.
No, the slight difference here, you still are required to, all companies still required to, as the accountants and the auditors will require, to prepare their financials. The companies will be required to prepare their financials, but that was usually kept within their own books or at most submitted to the auditors. The requirement of disclosure, that's the new thing that has come in. So whilst the small companies, medium and large companies will still be preparing their accounts, it's the question of submitting it to the registrar. That's the change that has been brought in. So the small companies will still be required to do their accounts as their accounting practice dictates and the auditors require, for tax purposes and for other purposes. If they are requesting for any concession from the government, they still have to show the accounts. But those accounts were not required to be submitted to the Registrar of Companies before, which has now become a requirement.
All right, and with that, we will take a quick break. Don't go anywhere. When we come back, more discussions on the Companies Act. Welcome back to the show. Our guest tonight is the Member of Parliament, Mr. Ashnil Sudhakar. Mr. Sudhakar, we're talking about the Companies Act. One of the points that stands out is in the original Companies Bill, which came before Parliament, if we look at the penalties section, some of the penalties or prison terms that were recommended was 1 year. Prison terms for certain breaches of the Companies Bill. This was in fact increased by your committee from 1 year to 3 years. Could you explain the rationale behind that?
Yes, thank you, Edwin. The rationale behind it is, if you have a look at the sections that are referred to in the schedule, Schedule 7, there's 5 sections that are encompassed in those sections. For a breach of Section 115, there's a imprisonment term of 5 years. For a breach of Section 484 to 487, the imprisonment term was 1 year only. And there was submission by some stakeholders that, or some submittees, was that to reduce it or do away with the prison sentences and change it with the monetary penalties. But if you have a look at the sections that are affected by those sections, Section 115 and Section 484 to 486, they refer to offences that are akin to criminal offences like a breach of good faith, dishonesty, insider trading, fraud. Now, obviously, it's good for any economy and it's good for all the businesses if the members, the company engages in honest practices. So to discourage dishonesty, to discourage fraud, insider trading, and a breach of good faith, the committee thought to increase the prison sentences from 1 year to 3 years to bring it in line with the breach of Section 115, which also deals with similar type of acts.
Of course, I'm looking at some of the sections in the Act, and it talks about penalties for falsification of books and liabilities. Also, the company failing to account for loss or part of the company's property. Could you explain that? I mean, if property goes missing inexplicably, are you saying that there could be a possibility of criminal offences?
Yes, of course, Edwin. If you have a look at, like I'll take you from the start, the submissions that came in from some of the submitters was that let's remove the prison sentences to encourage people people who want to become directors, secretaries, or members of the company should not be afraid of having those prison sentences. But it's good for any economy, any business. Even if you are trading with a company, you'll want the company to be held to account. Now, if a company is about to go bust, is about to be wound up, and some of the officers of the company then suddenly decide to dissipate the company's property, and they cook up the books, and they remove the property, transfer their own names, or at an arm's length transaction to their friends or family. Now, those sorts of offences is actually a fraud on the creditors. When the creditors come back to claim or to pursue their debt, they find that the company is basically a paper company. There's nothing left in it. So those kind of offences where you try to cook up the books, you try to change a few things around, and you try to dissipate the property, those will obviously be caught.
There are provisions to enable people to set up businesses more easily, the registration process, the requirements for directors and such. What are some of the more liberal decisions that are included in this act?
Yes, if you'd notice that in the current Companies Act that is in force in Fiji, you'd have to have, for a private company, to set up a private company, you'd have to have a minimum of 2 members, 2 shareholders. Now, what was actually happening was that if a husband wants to form a company, if a man wants to form a company and run it, he would just get his wife as a nominal shareholder. So 99 shares would be held by the husband, and 1 share would be held by the wife, or brothers or sisters. So what was happening was, in effect, it was just an added burden on the businesses. If I want to start a business, I have to get a friend or somebody whom I trust to have that 1 share, just to be there. So what this new companies bill is going to do is remove the requirement. You just can form a company on your own. I can call myself Sudhakar Limited and register a company, which makes it much easier to run. And there's another change that has been brought in, is the removal of common seal. You'd appreciate that there was a time when, and under the current act, if you sign a document for a bank guarantee or a mortgage, you have to put a company seal there to give that authenticity to the document. Now, the law is such that even if the company seal is missing, and the 2 directors or director and secretary have signed it, it still becomes a legal document. So there's basically no purpose of having the common seal. But it's not outlawed, it's just that it's not required. If you still want to keep a common seal, you still keep it.
So if I were to set up a company and going forward, if that company were to grow into a multi-million-dollar enterprise,
yes,
and I'm the sole owner,
yes,
does any change come in with regards to the Companies Act in terms of ownership, shareholders, directors?
See, if I understand the question right, if I'm a single member company, if I'm doing a business that earns, say, $10,000, it's still the same position. If it starts suddenly, if your fortune's 10 and you start earning, say, $50 million, it's still not a problem. A single member company can still earn that money, that amount of money, still have that income, but the disclosure requirements will change from, as I've explained earlier. If you reach 5 million, your disclosure is different. If you reach 20 million, is different, and above 20 million is different. But there's no problems absolutely in one person owning even $1 billion company on its own.
There were some submittees, some people who came up to the committee and said the bill in entirety is too complex and it won't help the business community. Won't help businesses to grow and progress.
Yes. See, there were some general comments like that. I mean, one particular submittee came and said that this bill is actually anti-women. But that was a general comment. When we asked specific questions, there was basically nothing in the bill which you could point out to say that this is anti-women. Likewise, to the question when people say that it's anti-business or it's going to make business more difficult. See, there was a perception that a general comment. Whenever something new or new law is brought in, there is a bit of apprehension, there's a bit of fear, but once you start practicing it, you realize that it's not anti-business. For example, I'll give you an example. If a foreign company comes and establishes into Fiji, and we have some local companies, 10 of them dealing with them. Now, those companies, the 10 local companies, are much more secure now in dealing with that foreign company than they were ever before. Because the foreign company, you must have heard about fly-by-nights companies, where they come down, they form a company, they acquire debts, and they fly out the next morning. So those creditors here are basically left on their own. They don't have anything to do. Now what the company's bill is doing now is that you have a local agent who will be responsible as far as that company, and to the extent that company, the foreign company, would be responsible. So all our local companies that are dealing with the foreign company are much more secure. So they can freely go and invest, they can freely go and take loans and secure finances, knowing very well that their position is protected by the Act.
And on that note, it's the end of another segment. We'll be right back. Back to the show. Our topic of discussion tonight is the new Companies Act. Mr. Sudhakar, one of the changes that I came to know of was about winding up notices and actually having a company wound up. Before, I understand, even if somebody owed $100, there could be legal proceedings and that company could be wound up. I think now the requirements are much stricter. What was the rationale behind this? And what changes are we likely to see?
Yes, the current position under the current Act is that if a company is unable to pay its debt to a ceiling of 100,000, that's $100. If you have a $100 debt, a company owes a $100 debt, any debtor, any creditor can issue a winding up proceeding against that company.
Basically, have it declared.
Yes. So if your company owes somebody $100, it's a very small amount. Anybody can issue a winding up proceeding, and that brings your company into embarrassment, and you can lose your dealers, you can lose your partners, trading partners by that winding up, because it's published in the Gazette and the papers. The position has changed now because the courts have time and again, I have practiced extensively in the High Court, in companies jurisdiction. The courts have time and again come and said that winding up proceeding should not be used as a debt recovering agency. So if you have got a debt, you have got your magistrates court, your high courts to go to and have the debt crystallize and have a judgment on that. Now to issue, to bank in a winding up petition straight away, there's $100, as soon as there's $100 debt, it actually stalls the company's business. So what the bill is doing now, it has put the ceiling to $10,000. So whilst now you can issue a winding up proceeding as soon as there's a debt of $100, you'll now be required to have a $10,000 debt before you can actually issue a winding up petition. And what that does is, it actually gives the companies a bit of breathing space that if you have a debt of say $9,000, you can still negotiate, you can still be pursued, those debt could be pursued by the magistrates court or the high court. But to issue a winding up proceedings, you'll have to have a undisputed debt. In fact, there's also a further requirement that debt has to be undisputed.
So it used to be a situation where there used to be winding up notices issued every week or every day, and there used to be so many cases that were in court. It seemed almost as if that winding up provisions were being abused previously.
Yes, I don't think abuse would be the right word, because I mean it might be used to. People were
taken advantage.
Yes, taken advantage of. People were the only reason why people would issue a winding up is because they have a gripe. They would have a debt owing to them by a certain company, and which the company was not able to pay or was not willing to pay. So they would issue a winding up petition. Now you are right on that. There would be many more winding up petitions in the courts because the ceiling was very small, $100. Now it's going to 10,000. So people would be encouraged to do alternative dispute resolutions to get the debt paid instead of running to the court straight away with the petition. And
this would include mediation or what sort of recommendations?
There's nothing recommended of that sort in the bill because that's outside the area of this bill. But they could pursue settlement. They could go to the small claims tribunal, or anything over 5,000. They can go to the magistrates court, and it becomes easier for the creditor too because the requirement is undisputed. So once the magistrate has had all the evidence and has reached a judgment without appeal, it's undisputed. So the company has to pay.
And do you expect this would also make life easier for the smaller businesses, which are sort of being accommodated in this bill?
Oh yes, that should be making it a bit easier, a lot easier in fact for small businesses, because small businesses sometimes find it difficult to pay debts, and if other methods are used, alternative disputes or the magistrates court process are used, then probably they could reach some amicable settlement outside court. But as soon as you, a small business that's already growing, already finding it difficult to breathe, and you suddenly put a winding up petition on that business, and it's advertised in the papers, in the Gazette, all the people who are trading with them will be very afraid to trade with them, and that suddenly will probably drain them out.
And when it actually does come to liquidation and winding up, are there any new provisions on how monies can be recovered by a debtor?
The general way to recover money is same as it was in the previous act. Is that if the company is wound up, if you issued a winding up petition or it's a voluntary winding up, the creditors will have a meeting and they'll appoint their proxies and they'll have their priorities. The secured creditors like the banks, mortgages, they'll be paid first and the rest will follow. That still remains the same. But the appointment of liquidators, receivers, the appointment has made a bit stringent. So previously the accountants body, FIE, would appoint receivers, but now it's gone to the Ministry for Justice, who will be responsible for appointing of liquidators.
And why is that being done? I mean, make it more independent?
It's basically to have a bit of independence and maybe a better control on who is appointed a liquidator.
So far as moving forward with this act now, how do you see the business climate adapting to this, business sector?
Yeah, thanks, Edwin. Usually how a piece of legislation is interpreted, that's ultimately rests with the court. A court system will eventually interpret the act. How it is, how workable it is it's only found out when it's actually put in practice. But this current act, it was a very thorough process of say 5-6 years, and it was adopted from a lot of countries where these provisions have worked very well. So generally, for business climate, I think it'll be a very good law for the businesses to thrive first and to be controlled. And for the investors, I mean, there was some fears raised about the foreign investors might not be willing to come to Fiji if this act come into force, but that won't be the case, because I'll give you an example. If a foreign investor comes to Fiji, they'll obviously want their trading partners to be more open, or more transparent and more honest, to say. Now, if the act opens these things up, any foreign investor wanting to come in and trade with, for example, company X in Fiji, just needs to go to the registrar, and the publicly available accounts are there. They can the foreign business can have a look at the accounts, how healthy the company is, and they could know that because the local company has not been prosecuted or the directors have not been charged for things, they're probably an honest company. And it's actually more encouraging for the foreign investors to come and trade with transparent companies here.
And on that note, Ashnil, it's time to take another break. Stay with us, we'll be right back. Welcome back to For the Record. We're talking about the Companies Act with Member of Parliament, Mr. Ashnil Sudhakar. Ashnil, I'm just looking at one of the provisions in the Act about managed investment schemes. This was never provided for before. Can you tell us what's the intent behind this provision and what does it actually apply to?
Yes, Edwin. Previously, in the previous Act, there was little or no reference to managed investment schemes. Let me give you an example of what a managed investment scheme is. For example, if you take a resort where time sharing is practiced, say for example Sheraton or Denrau or Westin, where there are different villas, and you can buy a share in the villas, and the actual hotelier will run it for you, but you still get your cuts from that and your revenue from that. Now that wasn't regulated before, but what's happening now is that under this Act, the managed investment scheme will also have to lodge their accounts and their documents, and to show how it's being run and what their financial situation is, and there'll be other requirements as well, like registration, etc.
And there seem to be some monitoring provisions under the Reserve Bank for any such business.
Yes, the Reserve Bank obviously is one of the regulators of this act, and the Reserve Bank will generally monitor how those managed investment schemes are being run, which is actually good for the people who invested and also for those hoteliers. It's more transparent. It's making it more transparent.
Does this also mean that people who may have been getting away with not having to pay taxes or avoiding their tax obligations are under more scrutiny under this?
Yeah, you could say that. I mean, I wouldn't comment on the tax part, but what I can say is that it's more regulated, so the Reserve Bank can actually see and know how those managed investment schemes are run and how's the money being shared or transferred.
And is this in response to the growth that we're seeing now, or was it something that came about as a response to the situation on the ground?
Yes, you'd appreciate that the Fiji First government is a very progressive government. They don't stagnate in time. They actually want to see progress. So with the economic progress that we have in the past 8-9 years, and with the discussions with the governor of the Reserve Bank for the past 3-4 years, we have at 4.5 or more of economic growth. Now these are some of the indicators of those, that there's more hotels being built up in the country. There's more. I mean, generally the tourism sector is expanding. So a lot more people would want to come and buy those shares and buy those villas and enter into timeshare schemes. Now, when that happens, it'll be good if there is some law to regulate those kind of businesses for the comfort of the people who want to invest, and also for the comfort of the hoteliers. And I mean, it's just an example. There are other businesses as well, and also for the comfort of the authorities that we are actually regulating the market that has just emerged.
A lot of these timeshare investments have people investing from overseas.
Yes.
They're not here physically, but they deal online. They know they have shares and they receive their dividends or whatever it may be in a timely manner. There are so many new requirements to have meetings of an investment scheme, to have directors. The entire business setup has been regulated now. How does this affect a person who may be in Australia but owns timeshares in Fiji?
Well, the companies itself can do their meeting structure by their own articles, because there's no longer a requirement to have a memorandum of association. You have your articles, that's the rules of the company. You can have your meetings by flying minutes too. You can have your meetings by email, and it's happening these days. It depends on the company how they wish to have their meetings. But you see that there's a residency requirement as well. In the definitions, we have put a residency requirement, that is to be classified as a person who is ordinarily resident in Fiji. You must have spent 6 months out of the previous 12 months in the country. Which is a bit more relaxed than what we have in other laws, where some laws require you to be here for 18 months in the previous 2 years, or maybe 8 months in the previous 12 months. But this one has got 6 months of previous 12 months. So that is one of the residency requirements. If you are here, even if you are foreigner and you have some degree of permanence in the country, you are considered local.
How does the Act enable new business? Somebody who wants to set up a business in Fiji.
See, there's the registration of business, which used to be a separate law, has been encompassed in this Act. It's been brought together with our commitment of having a one-stop shop, so that we don't have to flick through 5-6 different pieces of law to register business. It's all in here. What it does is that it's making it more it's rather easier for business to register. What it says is that for the very small businesses, if I'm running a shop or if I'm running a business in my own name, say for example, if you say Edwin Vegetables, you don't have to register as such, because your first name or family name has been used. And if you look at section 28, it's provided there. Section 32. That if your business name includes your family name or your individual name, you don't have to register as a business. I mean, you still have to pay a business license, but you don't have to call it a business. But if you start a business and start calling it with say a fancy name, for example, say foreign vegetables or say local vegetables. Now you don't have a family name or your name in the business, so it's very hard to identify who that person is. In that case, you'll have to register it under a business name. So that when anybody searches for your company, they'll be able to see who the members of the company are, who owns the company.
That's for a small startup company.
Startup companies, yes.
And what if there was to be a larger investor coming in, somebody with millions of dollars? Because, as you said, running from pillar to post has been one of the problems.
One of the problems of the ease of doing business in this country has been difficult, but it's going to improve. We anticipate it's going to improve. To a question of what happens when a larger company comes and wants to, with a larger investment, wants to set up a business in the country. Now, this one thing that's been made easy is that you don't have to look for another local director. You don't have to look for another director. You can start on your own. If it's a foreign company, you'll have to have a foreign agent here, a local agent for the foreign company, who will be the one who will carry your responsibility. And you don't have to have a memorandum of association, the MOE anymore. What used to happen was that before, when you register a company, you submit documents, the articles of association and the memorandum of association. The memo was binding the company to a certain task. You can only do these number of things. But now, with the memo gone, the company actually has an individual's power now. So one person can do whatever business they want to do, as long as it's not illegal.
All right. Let me just pause you there for a moment. We have to take a break, but we'll continue this discussion.
Okay.
Don't go anywhere. We'll be right back. Welcome back. We're almost at the end of the show tonight. We're talking about the New Companies Act, but before the break, Ashnil, you were explaining the reasons behind removing the Memorandum of Association for large investors. It sort of gives me the indication that it frees up a company to diversify.
Yes. This is actually linked to your first question of how it's going to make it easy for a large investor to do business. As I was explaining earlier, previously, when you register a company and you put in your MOA, Memorandum of Association, that would give the objects of the company. So if the object said you can do 12 things or 10 things in the MOA, that's all you could do. If you want to diversify, if you, for example, today you're selling cars, tomorrow you want to buy and sell land, you have to call an AGM or an SGM and change those requirements and file those requirements with the registrar and say, okay, the company will now venture into another business. But what is the removal of MOA, that has actually done is that a company will have an individual's power. So today you're doing business A and tomorrow you want to do business B. You don't have to go through the extra process of convening a meeting and changing the memorandum and getting the approval of the registrar. You just start doing it on your, just start diversifying on your own. I mean, of course, subject to the tax requirements, the licensing, and provided it's not an illegal business. But yeah, it's making it easier.
Do you think this New Companies Act is more attractive for new investors?
Yes, I mean, my reading of it, I've read it quite a few times. As I said, our committee sat through it for 25 days and 5 days straight reading and corrections and everything. We have gone through it many times. My view is that this act is going to make it easier. It's going to make it more attractive for people to come and do business here. I mean, as I said earlier, when somebody comes to a country, they want to deal with honest people, credible people, transparent people. And the companies who are here, they are encouraged, or they are in fact asked to be more responsible by having the disclosure requirements, having the restriction or the penalties that are there, that you must be an open and transparent business. Now, when foreign companies foreign investors see that we have an economy here in Fiji where everybody is so well disciplined and so well organized in terms of doing business, so they'll be more attracted to come coming to Fiji to invest, as opposed to a country where everybody is keeping everything very secret, and a foreign investor might think that, oh, should I go to company A or B, because they're not showing me anything. I don't know what I'm going into, how deep the waters are. But when I come to Fiji, I can actually gauge everything here before I even land here. I know what the economy is like, what the company is like.
Do you think some companies would be reluctant to abide by the disclosure requirements in terms of their finances? I mean, a lot of companies, of course, multi-million-dollar companies would be hesitant to open up their books.
Yes, that was the submission and perception of some of the submittees who came to the committee, is that if I'm doing a private business, if I'm earning X amount of dollars, why should I show the people, the public, of what amount of money I'm earning? But you see, you have to balance the privacy issues with public policy issues at some stage, and this act is a very good balance between the public policy and the financial secrecy issues. Let me give you an example. If you are an investor and you want to go to deal with company X, you'll be more comfortable in knowing what that company is worth, instead of just going there and asking that company that, can I see your financials? The company might say yes or no. If it's yes, it's good for you. If it's a no, then you don't have anywhere to go. But today, if you want to deal with a company, I mean, that is after this act coming to force, if you want to deal with company A and you want to know how big or small that company is, you can just straight away go to the register of companies and check their accounts to see, okay, I'm dealing with a substantial company. I was doing a case some years back, it's already decided. In that one, there were two companies, very similar names, and just a word or letter different. One company held all the properties, and one company had all the documents in their name, like contracts, tenancy agreements, and every dealing was done by company B. When all the property, everything was owned by, even the bank accounts were held by company A. So when the company is closed, when the creditors started running after their to secure their debts, they were told that, I'm sorry, company B has got zero property, you can't get anything, because company A was holding everything on behalf.
Its name.
Yes, so that kind of situation is rare, but it's not unlikely it happens, and it's more secure. It would have been more secure had this act been implemented 10-20 years ago, for those debtors to come and see, okay, I'm dealing with company B, let's see what it's worth.
But you would recognize that a lot of companies would be hesitant. They would feel vulnerable and exposed if all their finances were sitting in an office. And from this act, what protections are available to these companies?
What we have done is, in the act itself, it's not that once you file your accounts, once you file your documents, financials, it doesn't become automatically available to the public. You have to ask you have to go to the registrar's office. You have to ask, and you have to the word there used is the registrar may disclose the accounts. Now, if I go to a company just for nuisance and to the register of companies and have some malicious agenda and try to bring the company's accounts out, the registrar will be the judge there, that, am I a genuine person? Why do I need the accounts of those companies? So the companies, the large and medium and small companies who are required to submit their accounts, they will, they can rest assure that it's not going to be like putting all their accounts in public domain for everybody to view. The registrar still has the discretion to show it to the person who may be genuine.
And so one would have to come up with a valid reason for wanting access to these accounts. There would be some sort of...
There's some sort of regulations will obviously cover that. The regulations are still in the process of being made, but because we have given the discretion to the registrar, it doesn't say the registrar must disclose. It says the registrar may disclose. Now, giving the discretion to the registrar may set up his own rules. The registrars are entitled to make their own rules to see people who come to his office to fish information are some genuine people. And in fact, it's better for the members of the company as well. If there's 100 people in a company and 10 of them don't know what's happening with the company's accounts, how's the company being run, so 10% of the voters, that is 10%, 10 members of the 100, they can write to the company registrar for a small company and say, can we please see the accounts? And the registrar will then direct them to give the accounts.
And just lastly, as we come to the end of the show, we've spoken about the impact on the business climate, business owners, we've spoken about debtors and liabilities, but the core of any business is the consumer. Some years down the line, let's say 5, 10, 15 years down the line, how do you hope that this new Companies Act changes things for the consumer?
The consumer, of course, there are many categories of consumers, I would appreciate, and what this act hopes to achieve is, as I said earlier, honesty, transparency, accountability, and less stringent requirements. Now, these are 4 or 5 of the main aims of this act, to make things more transparent. I mean, everybody will appreciate, you and I will appreciate transparency. At the moment, I mean, how many companies do you know who are trading, and what they are worth, what risks they are running, are they about to go bust tomorrow? Now, these are some of the things that the consumer would want to know. If you're investing in a say a land development company, we have had many cases where people put their money in, the company just goes bankrupt the next day, and the money is lost. Now, now what we'll do is, now what the consumer can expect to do is, before he puts puts his money into a company, say a land development company or some company, he has got his peace of mind that he can obtain by going to the registrar's office, seeing the accounts, and basically getting the information around from the good word that's spread around. If a company, for example, has not had a single charge or single offence under the act, then obviously we all know that that company probably is a better company to deal with, as compared to a company that has had 10 or 20 dishonesty offences in the past 10 years. Now, that's the consumer protection. If we come back to your question, what do we have for the consumers? Now, this is what we have for the consumers: the peace of mind that this act is going to bring to the consumer.
All right, and with that, we come to the end of our show tonight. Thank you very much for being on the show.
Thank you, Edwin.
And best of luck in the future.
Thank you very much.
Thank you. That was our show for tonight. Remember, if you have any comments or questions, you can email us for the record at fbc.com.fj. We'll be back again next Sunday. Until then, good night.